Testing mic from judge's chair. Testing mic. Testing microphone.
We'll say only kind things about you and the judge.
This general sitting at the federal court in Ottawa is now open. Presiding the Honorable Madam Justice says, before the court file number T-909-15 between Sahar, Jaffal and the Honorable Davidson, the President of Universities Canada, previously known as the Association of Universities Colleges of Canada, AUCC. Ms. Sahar Jaffal is appearing on behalf of herself as the applicant, and Mr. Aaron Rubinoff and Mr. Brett Hodgins are appearing on behalf of the respondent.
May be seated. May begin.
Well, good morning. We're blessed by some pretty wonderful weather for the walk over here today. So I just would like you to know that I have Christine Taussig-Ford with us today. She's the Vice President and Chief Operating Officer of Universities Canada. And so as you would have seen from our materials, this is a motion to strike the application in this case under Rule 2200 or 221, both as not disclosing a cause of action and for being frivolous and vexatious. And I think if you from our materials, it's, I guess, very simply, our position is that there's no decision that's capable of being attacked in the context of these proceedings. That the Universities of Canada was not acting in the capacity as a federal board, commission, or tribunal as contemplated under the Act, and that for reasons that I'll canvass with you, the application itself is frivolous and vexatious. And so, with your leave, what I would like to do is to take you through what I would plan to do today is to start by going through some background. In that context, look a little bit at the parties, what happened that led Universities Canada to be involved in this chain of events, and what it is that the applicant's looking for. Just by way of background, because all of that information, I think, will be useful when we look at the analysis of the issues that we've raised. And so once I've done that, then I'd like to take you through each of those grounds of attack that I just spoke about a moment ago. So that's kind of where I'll be going. And of course, if you'd like me to go in any other direction, I will do that as well.
No, that's fine. Thank you.
So the applicant, I don't think I have to spend much time on the applicant, other than to say that she's self-identified in her materials as a PhD student at McGill University. And so far, I think, in my trying to come to grips with the case that she's put before the court, I think that's enough of a starting point. The respondent's a little bit more interesting, and what I've looked at, or I think that the court is able to look at, because obviously we'll get into this later, and I'm sure you're familiar with the case law around the fact that one can bring this kind of an application, or motion to strike an application, even though the rules talk about actions in certain kinds of circumstances, but then typically the court's limited to looking at the pleading. Here we have an application, so the pleading's a little bit different than a normal pleading, and the cases don't talk about it much, and I'm sort of taking as we would look at the application and the affidavit evidence as if that formed the pleading. And I can't even tell you whether I'm entirely right in that, but I think it's sort of the most generous way of doing it from the perspective of giving the applicant the best chance of her case standing. So if we do it that way, I think we're doing it in the way that's most generous and the fairest way, as opposed to just looking at the application as if it were a statement of claim.
So you're in agreement that we can go beyond just the application?
I think we are in agreement because we intend to do that, because I think it helps a little bit in this case to understand the case that we're attacking, and keeping in mind that our attack is really it's twofold, because it's both under 1A, the no reasonable cause of action, which does have that limitation, albeit for a statement of claim typically or for a defense, but also under C, the frivolous and vexatious. And when you look at the cases, something that's frivolous and vexatious, at least one judge says, well, it's sort of an abuse of the process of the court. And on that part of it, I think you could look at materials in any event. So, but because we're looking at something other than what was normally contemplated by the rules, that's the position that we'll take, is that, well, let's look at the application and the affidavit, because the applicant's case can't get any better than what is in the application and her affidavit. It can't get any better because that's the end of the evidence. And so looking at it from that perspective at the beginning, as I say, we want to take a look at, and it helps us understand what the respondent is. What I'd like to do is take you to 2 or 3 of the exhibits, and where they give a description and some meat around who the respondent is. And I think that again, it will help us start or give us a benchmark for our investigation. So the first exhibit I'd like to take you to is Exhibit I from the applicant's affidavit. And I'll provide you with a copy.
Oh, you have a copy?
I do have a copy. And I can give one to the applicant and then one to the court. Because I believe these were on the CD. That's how they were provided to us and possibly to the court in the same manner. So we just extracted a couple of exhibits from the CD. So this first exhibit is something that the applicant has included in her affidavit, and it is a copy of an excerpt from the Office of the Commissioner of Lobbying of Canada. And the Universities of Canada is registered as a lobbyist, and this is the description that was provided on its website and ultimately found its way into the Office of the Commissioner of Lobbying. And it's incredibly instructive, and I guess I was going to say this later, but I really want to underline as many times as I can that they are registered as a lobbyist, and this comes from the Office of the Commissioner of Lobbying of Canada. And I know of no case where a party can end up being characterized as a federal board commissioner tribunal and at the same time be registered as a lobbyist to lobby the government of Canada. So, but in the description, it's very helpful. Universities of Canada has represented Canada's universities since 1911. We are the voice of Canada's universities. Our advocacy ensures the higher education is recognized as vital to Canada's prosperity and quality of life as a knowledge-based society and economy. We are a non-governmental and not-for-profit organization funded through membership fees and revenues from contract management services and publication. Our mandate is to facilitate the development of public policy on higher education and to encourage cooperation among universities and governments, industry, communities, etc. We provide services to member universities in 3 main areas, like grouping, etc. So what we can take away from that is that it is a non-governmental, not-for-profit, not funded by government. It has a mandate to lobby for its members and provide services to its members. So that's the first piece of more useful piece from my friend or from Mr. Jaffal's application, and it helps give us some insight into who they responded to. The second thing, this doesn't come from an exhibit. We forwarded to the court, and I apologize it wasn't on our materials to begin with, a copy of the Act incorporating the Universities of Canada, the Association of Universities and Colleges of Canada, which has since been renamed. And I'm not sure if it made its way to your file.
Yes, I did.
You did. Okay, so, and again, I don't need to spend much time with it because, not surprisingly, the purpose, this was in the days where not-for-profit, this was the way one could gain its legal legal status, as opposed to now there's different kinds of legislation which have different kinds of opportunities. But what's important about this, and we'll see it when we get to the cases, you'll see that it's a merger of some legacy groups. Paragraph 2, the objects of the association shall be to foster and promote the interests of higher education in Canada, and for the affairs of the association shall be managed by a board of directors in accordance with its bylaws. And
just before you go on, do you have a copy of that?
She does. We did send it to her, but I can also provide an extra copy. And I'm sorry, I meant to mention that we did provide it to her. So it's sort of proving a negative. We provided it to the court so they can see the minimalist nature of it, because it will be important later in the analysis of what's a federal board or commissioner tribunal, because you need to look. One of the places you would obviously look is to the Constantine legislation and see whether there's something there that changes the nature of the power or authority being exercised at a particular moment in time. But what's evident from this is that there are no legally or statutorily provided, there is no legally or statutorily provided mandate. It's silent on it. It's entirely up to the organization to manage itself according to its bylaws. There's no role provided, either provided for the organization by Parliament. There's nothing saying this is what you shall do, and no role for Parliament or any agents of Parliament. There's no controls or guidelines impacting on how the discretion of the organization should be exercised. So again, these are sort of helps us understand when we get to our analysis later. The last exhibit I'll show you is Exhibit K, and
Now, I understand that these documents were on the CD.
yes,
Which I don't have a copy of. I just want to make sure, because there is an issue that will need to be addressed with regards to the filing of documentation and
Yes.
whether or not this court is supposed to rely on that information. So you can address that now, you can address it later, but I just want to make sure that everybody is going to be working from the same premise in
Yes.
terms of documentation.
I guess our operating the initial affidavit that we received came with a schedule of the back listing exhibits, and then the exhibits were provided to us on the CD. And so from that perspective, we were content that that tranche of materials, in the circumstances, I mean, it's a somewhat, from my perspective, it's a somewhat unusual circumstance that Ms. Jaffal finds herself in, where she's representing herself in this particular kind of case. And so we've tried not to be overly mechanical in how we're treating it, trying to be as fair.
Okay, I just want to make sure that I understand, and I'll get to speak after. The applicants filed an application for judicial review
Yes.
in June, the beginning of June, and you were served with an affidavit and exhibits. That's what you're referring
Yes.
to. Okay.
Yes.
Now, the court doesn't have that documentation because it wasn't filed at the time, as far as I understand. Now, last Friday, there was a direction that was issued that the applicant had to file any supporting documents for the purposes of this motion. That had to be done within the prescribed time
Yes.
frame. I know that I was informed this morning that there are documents that have been brought to the court. I don't know if it's the same documentation or not, and I don't have a copy of them with me right now. So, do you take any issue with the production of documents?
Well, we don't in terms of the CD. So, and I apologize, I didn't realize the court. We had assumed that the affidavit that we received and the CD we received was filed at that time with the court. And so, and whether it was or wasn't, I don't have any particular issue with those materials, because we have to be able to, as I said at the outset, I want to be able to argue our motion. The materials that are coming after, we would object to those being filed for the purposes of today's proceeding, because particularly if they weren't timely, because we don't see how they speak to the issues in this particular proceeding, and it's just so. I think if we were able to demarcate them in terms of our position, the original application is sort of at issue in this case. We'd have to put our, quite frankly, we saw it as there was a request to be able to file audio tapes and some other materials, and my friend sent a letter characterizing what was in them. And I guess I have to say I didn't pay a lot. We sort of read the description, but it's not evidence, and we felt that the issue of the filing of those other materials would not be part of this application today, because and to the extent that we were unsuccessful and had to deal with those issues, we'd have a chance to formulate an appropriate position as to whether they should be part of the application or not subsequently. But certainly our position would be they wouldn't be properly before the court for today. At best, it would be the application and the affidavit as filed that formed the basis for the application. The other materials coming late and not part of the record at the right time, with respect, I don't think that they should be part of this case, and we should be allowed to ask to have the application struck on the basis of the application and the record that was filed at the time.
Okay, but that the rule that stipulates that there's no evidence is with respect to the first ground of the motion to strike, when somebody is also bringing a motion under 221C.
Yes.
The respondent on the motion would have the ability to produce a respondent's record.
Yes. And I guess you're saying that she could have a fresh record in relation to this motion. So to the extent that those materials that she's proposing to rely on the audio tapes, etc. I guess we didn't read her request that way, and that may be our mistake, because it seemed like there were further requests to file more information to buttress the original application, as opposed to somehow answering the specific issues in the motion.
Okay, well, maybe I can ask if the documents that have been brought to the court, they were provided to counsel for the applicant on the motion?
All these documents, yes.
And are those the same documents that were filed originally?
Yeah.
Are not filed because they weren't filed. They were served in, I think, June. The end of June, you served an affidavit with exhibits on the opposing party, and the ones that you brought to the court are the same documents?
Same documents, yeah. The addition is just my response to the record, because this is like the additional, and the request for the voice recording. But in my affidavit, I was mentioning like some of the contents in the voice recording. To say, for example, why I do requested or sent this request to University of Canada.
Okay, but I just want to know if the documents are the same.
So I'm advised that we have reviewed them and that the documents are the same. So
Okay.
I apologize.
All right.
Maybe that's why I didn't focus when I was preparing on them once I knew that was the case. So I suppose the issue then that remains would be the audio tapes.
Okay, but if we because you've produced two documents this morning, I just want to make sure that the production of these documents, there's no contest on whether or not I can be using them.
Yes.
Okay.
And we're content that they came and when she put together her application record, or her motion record, then she did take the exhibits from her original affidavit.
Okay, that's fine. Okay, thank you. Go ahead.
I hope that helps. So the last, I've given to you Exhibit K, and I assume the numbering is the same? Yeah, okay, fortunately. And I just wanted to draw this to your attention because this is an excerpt from the University of Canada's website. And amongst other things, it talks about the criteria for membership. And I suppose it's of some moment, but because of some issues that are raised by Ms. Jaffal, but it's useful for you to have this in front of you at various times, and perhaps when you're deliberating, because you can see that the context of membership is one that's very much directed at university governance, not the micromanagement of what goes on in a university. It's a very different piece. The criteria for membership relates to bricks and mortar, boards of directors, mission statements, things at the highest level of what the university is and if it meets and funding and the like. And so if you, at Exhibit K, it talks about institutional members, which are the meaningful members for the purposes of today's exercise, and it gives the details of the criteria for belonging to what I'll refer to throughout as a private club, essentially. And so just even on the first page, there's numbers and then indented bullet points describing, but you can get the flavor pretty quickly. One, has the powers it purports to exercise pursuant to authority granted by the Crown or by statute or by formal agreement with its affiliated federated university. Or two, it has governance and administrative structure appropriate to university, including details. Three, it has an approved, clearly articulated, and widely known accepted mission statement and academic goals that are appropriate to university and that demonstrate its commitment to various things. Four, it has its core teaching mission, the provision of education of university standard, with the majority of its programs at that level, and then et cetera. So it's directed at macro level governance of universities, and I think that's important to understand that that's what Universities Canada is all about. It's a private club that lobbies for its membership in relation to matters of higher education, and membership is based upon these kinds of fundamental governance realities around institutions in Canada. And I guess the flip side of that is, you'll obviously hear from us, that to the extent that it matters in this case, the criteria for membership and the manner in which the organization operates doesn't have anything to do with the kinds of complaints that are being made by Ms. Jaffal in this case. I'm somewhat, it's almost frightening when I say the words as if that there is any kind of connection or that there's even a debate about it. But I guess I have to say that the nature of this organization is not the kind of organization that would deal directly with somebody like Ms. Jaffal and her complaints, or even in dealing with its member organizations or its member universities, does it deal with these kinds of issues.
Just so that I understand, you say examples of complaints that wouldn't be falling under this. What kind of complaints would actually fall? Like, would there be any complaints, and what type of complaints would be addressed?
Yeah, it's not a complaint-driven organization. It's a collection of like-minded and like-structured organizations that then lobby the government on education issues, and then it does they provide education and guidance and direction to its membership, and so they partner with other similar organizations to provide conferences and education material and direction to people. So it's not set up to be a complaint-driven organization. What can happen is if an organization changes its mandate somehow, or changes its structure or its funding. Because one of the things, it has to be not-for-profit. So you could have a university that changed in its fundamental setup and went to become a profit-driven organization for various reasons, and then its membership would then have to be assessed. So from time to time, the membership of organizations in Universities Canada is assessed if some aspect of its governance comes into question in relation to the criteria.
In terms of the governance of the universities, first of all, I guess my first question is, is it automatic that a university would be a member of this association?
No, it's voluntary. Not all universities are a member. You have to choose to seek membership. It's a prestigious and high-profile organization that does represent the interests of universities in Canada. So many universities, I might even be able to say most, would be fair, but not all. So and that's very important to understand. That it's not like the Law Society, where if I want to stand here in front of you as a lawyer, I have to be a member of the Law Society. And so it's an organization that has some similar characteristics, but it's driven by legislation. It has a specific mandate, and I have no choice but to be there, which is sort of the easiest analogy that I was able to sort of think of as I was going through this and trying to make the distinction in my own mind. This is more like, I suppose, like the CBA, in the sense that you can choose to be a member from time to time, depending if you want to go to the conference that year, but you don't have to be. But it's a lobby group, it does educational things, and I suppose if I was a member and stopped being, and so if I was a member and I stopped being somebody who had the criteria to be a member, I stopped to practice law, got kicked out of being practicing law, then they could have a review of my membership and say, look, you don't meet our criteria anymore, out you go. But nothing that they do is driven by government or directed by government, and I don't have to be there. I think that's fundamental to this, and we can see it in some of the cases, is that a voluntary organization that has entirely it's left to its discretion to determine what it's going to do or not do vis-a-vis its members cannot be a federal board, commission, or tribunal for the purpose of judicial review.
Okay, maybe I'm too far ahead in your argument, but I'll ask the question anyways. To the extent that your argument is that it's voluntary, it's not a question of it's a macro level of governance. Supposing, for the sake of argument, that there was an issue of wrongdoing that was systemic within the university, what would be the authority to look into whether or not wrongdoing was going on at that university?
Well, we've seen it would lie to the university administration, it would lie to the human rights tribunal. It would be appropriate depending where that university was and how it was structured. It would lie to the Minister of Education, depending on the province in which the university found itself. But it would not lie. The only thing that University of Canada could do, if somehow it got wind of the issue and felt that it impacted on one of the criteria for membership, is to say, well, I'm not sure we want you to be a member in our organization anymore if what's going on somehow impacts on one of those governance issues, which at my understanding is that just that's not what happens. The universities don't, because the organization itself isn't interested in whether or not Department A or B or several departments are engaged in sexual harassment or discriminatory practices or discriminatory policies. Those are things the university will have to manage, and we have institutions in Ontario and all the provinces and federally to deal with those issues. But it's this club wouldn't be the one that could then fix it. The only thing you could do, if depending on the conduct, and I realize you gave us a particular
it's a hypothetical
high level, but if we drill down and it was an issue of insidious policies that were discriminating against a particular group of students, it would be hard to imagine that would be rife throughout a university. So if it was by department, the Universities of Canada would have almost no interest into it. If it was insidious throughout the whole university, then it may have an interest in saying that, and analyzing its criteria, and there may be a place where its criteria, where it ran afoul of its criteria, and it could, if it so chose, then embark on a process to assess the availability of membership of that organization. But it couldn't then go and say, do a better job, award damages, punish them, make them set up a new structure. There's nothing that they could do. The Parliament has not, to say Parliament hasn't chosen to give them that power would be to credence to an argument that isn't there. Parliament didn't even put their mind to it. This organization went to Parliament and said, we have this act so we can set up our private club. Parliament didn't do it the other way, the way we've done it with using the Law Society example, where you had a societal need to set up somebody that watches over lawyers, doctors, pharmacists, etc. We have to have that, and it's driven from governmental policy, and then structured with input, obviously, from the particular industry. And that's not what happened here. It's just, knock, knock, could I please have an act because I want to have this private club. And so, I'm sorry if I went too far into it.
No, that's fine. Thank you for the answer. Go ahead.
So taking together the background that we've looked at, in terms of what it does, what does the Act say, membership criteria, I guess I've beaten this, I've said this, that it's a private club for universities, it's not exercising a public function in any way, it's member-driven and financed, and there's no government input or control. Those are kind of takeaways that are useful So if we have that, there's the parties to some extent, and we may get into it a little bit more down the road, but I wanted to then, as I promised, just address what happened, but I'm doing it at the highest possible level. I don't intend, other than perhaps when I talk about the frivolous and vexatious nature of the claims, I may delve into the nature of the specific complaints, for example, against McGill and some of the other parties, and I'll try to help the court by giving you a summary with some pinpoint references. But for most of my submissions, I'm not really going there because the actions of McGill, our basic position is, have nothing to do with Universities Canada. So on this sort of second issue of, well, what happened? I think it's just a useful way to look at it at a high level is that Ms. Jaffal did make known a series of complaints that she had about her university, McGill, to Universities Canada. So there's no debate on that. We do acknowledge that she came to the offices, that she wrote emails, and that she made phone calls and communicated her complaints about McGill. In the simplest and fairest characterization of what happened was that Universities Canada advised her that it wasn't in a position to address her issues and directed her to the Dean of Students at McGill University. That's their conduct. And that's evident on the face of the application. I'm not, and from the affidavit material. That's the essence. And there's we'll get into it a little bit later. There's some allegations that because she wasn't satisfied with the way she was treated, that she's put on to the people, that the support staff and the frontline staff, some allegations of conspiracy and efforts to thwart her complaints, and I'll give you those references later. But in terms of the narrative, what happened was she came and asked and submitted these complaints, and she was just told, look, that's not in our bailiwick. We'll connect you with the Dean of Students at McGill University. You can deal with it. So what's happened here is she's not happy with that particular outcome. We'll get into this in detail, but she's asking that Universities Canada investigate and sanction McGill for McGill's alleged mistreatments of her. And it's important so this is sort of the third leg of my background, is what is it that she's asking for? Because that's not insignificant given the powers of this court. So I'd like the notice of application. I think I have my copy here. So I have, I hope everybody has it, the notice of application itself at pages, we'll start at page 13. And obviously will not read to the details of what we find under what she's asking for each paragraph. But we can carve out of each of these paragraphs certain requests. So one, she's asking the court to establish a visiting committee appointed by the board to investigate the fulfillment of McGill to the requirements to be a member of the AUCC and the commitment to the agreements of the membership and to the agreements that allow it to provide education as AUCC gave the authority to McGill. And so she's asking for an investigation that can result in the Universities Canada extracting some sort of a commitment for McGill to behave in a particular way, something which it doesn't have any authority to do. It doesn't lie within its mandate to make McGill do anything. And we'll argue this at the end of the day, I don't believe this court has the ability to make McGill, to tell the Universities Canada to go do something that will result in it telling McGill to do something. But it goes on at this first request, and if you go down to the sort of bottom half, after you see in the side a reference to and Article 5, and if we just keep reading, I would request, on the next line, comma, I would request to allow me to meet this visiting committee, give them the proofs, documents and voice recordings, and request from the committee to interfere in the evaluation of my PhD, according to the ground 2 of the role of AUCC in advocating higher education, and the right of the committee to evaluate the student, etc. So it's difficult. I'm going to say, with respect, it's not particularly clear at all. But and that's something that will be important later in our argument. But what is clear is that she's asking for this court to order my client to get involved with her PhD and with her candidacy as a PhD student. And the last line is, I am requesting the interference of Universities Canada till I get all my rights and my degree, as there is no integrity at McGill. So, I guess collectively, stuff in number 1 is the first kind of aspect of the request. Just look at your summary. We get to the second point. So I just sort of had a cheat note because it's long, but essentially that one's the short. So 2, because of the behavior of the members of AUCC, of all the members, and the possible behavior cover of the visiting committee to McGill, so now there's an anticipation that the committee that this court sends to McGill will somehow misbehave. I am requesting, please, to put the decision of the visiting committee that will be appointed by Universities Canada under the custody and review of the court, meaning that Universities Canada should submit a convincing report to the judge about the outcome of the visiting committee with a copy to me. So this court should supervise the investigations in the previous paragraph and the monitoring of her PhD, and presumably by giving a convincing report, she means it should be this court has to make sure there's a report that results. I think you can fairly read from this a report that results in her being granted her PhD, so she's asking for the court to predetermine the outcome of this investigation. In any event, 3, paragraph 3 talks about damages. So I'll leave it at that, and I'm sure the court would understand what the significance of the request for damages is. And we'll obviously take what we've included in our materials cases that stand for the proposition that this court can't award damages in this circumstance in the manner in which she's requesting them. Then 4, my sheet note is that the staff will be held accountable for their intentional misdirection, delay, or complaints. So I'm requesting that the receivers of the documents that were sent to the Honorable Paul Davidson to show if they have written authorization from the President to open the envelope and give written justification for intentionally wasting of time since March and breaking the confidentiality, etc. And then saying that the University of Canada will be responsible for the consequences of the decision of the grievance that was held at McGill. So, and responsible partially for compensation due to mishandling requests. I guess in there, there's an attempt to make individual people, and I think they even named Helen Murphy, responsible and somehow be punished. I think it overlaps as well as some of the other reports. I also say, and again with respect, and it will be relevant later, that it is somewhat baffling, unintelligible, and difficult to follow what's being asked for. And I say those words not to cast aspersions, it's just because they will have some legal relevance as we go on. Because I do struggle to characterize. I mean, I have ways that we characterize it, but when you go and look at actual words, there may be a debate about whether I'm capturing it entirely correctly. But that's because it's not really possible to understand what's being promised. Number 5, McGill should be kicked out of Universities Canada for a minimum of 3 years. So the request is that this court tells Universities Canada what it should do with one of its members. And again, and we'll get to it, private club, no limits on its discretion and how it should function. And yet there's a request that this court should tell it how it treats members. And then the last, number 6, I'll just read our characterization. There's a request that there be a a system, and that I'm using the language from the document, system run by University of Canada. So there's a request that we be required to set up a system to prevent slave labor occurring at McGill, and then it has to be publicly announced that this is going on in the media. So I'll, for obvious reasons, come back to that, but I think all of this background is useful to have because I can be more efficient when we go into the nitty-gritty of our analysis if we understand what's going on. So that takes me to our first point, that there is no, and I'm not planning on taking you through our factum per se, to the extent that if I remember, I will tell you, for example, here we start at paragraph 26. But I tend to elaborate on our submissions and not read you the paragraphs. But that's where, and it kind of flows from there where we start to deal with these issues one at a time. And so the first point that we raise is that there is no decision or act that can be the subject of a review. So it takes me back that at taking it at its highest, so we characterize what happened as Ms. Jaffal came and asked or submitted a complaint. We explained to her, this isn't the right place, go here. So I think taken at its highest, you could say, well, which the allegation or the complaint is that Universities of Canada failed to process her complaint and to embark on the serious investigations, and failed to do what she thinks it ought to have done in terms of meting out discipline against McGill and fixing McGill's problems. So if we put it at its highest, that's how one could fairly characterize it. So what I'd like to do to go through this analysis with you is take you to the the Federal Court of Appeals decision in Air Canada and Toronto Port Authority. It's at tab C of our materials, and it provides a very useful roadmap from our perspective as to how we can solve particularly the first two questions or the first two propositions that we put to the court. One is that there's no decision as contemplated under the Act, and secondly that the impugned entity was not acting as a federal board commissioner tribunal to contemplate under the Act. And this Air Canada decision takes on each one of those questions head on, and even has great headings that say, here's this question, and then it takes us through it. So in a way that I think is very helpful in this case. So I'm going to take you to page 35. Yes, page 35 of the record. So maybe just there's the chicken scratch numbers in the top right-hand corner, but they're all very legible. So that seems to be. So I'll take you there, and we get to this dealing with this first question. And so I'm going to do what I don't often do, but the way that it sets itself up, it makes for such a straightforward approach to this problem. So I'm going to actually really look closely at this case. So in this, and I guess just to start, the facts of the case, they're sort of useful and sort of not, but just at a very high level, as the Toronto Port Authority is, amongst other things, responsible for where we fly in and out in Port, basically. And in the olden days, Air Canada Jazz flew into there, and then Air Canada lost interest, or its business plan didn't work, and Porter started getting more and more of the slots. And the Port Authority was charged with responsibility for, there was being a predetermination as to how many slots there would be for flights to come in and out, and they were responsible for giving those out to different carriers. I mean, historically, there was Air Canada Jazz, then it disappeared, and then Porter got a lot, and there was still some leftover inventory, and there was a debate about, because Air Canada had an interest of going back in, and so then there was this debate about how they were going to sort out who would get a few more of the slots. And there was an attack that Air Canada brought on a particular decision in a moment in time, and that decision was resolved, I believe, against Air Canada, but in terms of how slots were allotted, but a judicial review. But then that was in the past. Then, flashing forward, the Port Authority issued a series of bulletins that said, here's a process we're going to follow, and then here's how we're going to implement the process. And Air Canada attacked those as if they were decisions. And interestingly, in the case, ultimately the court said, well, we're not too fussed about decision or not. They're not really decisions, but there's still an act, an administrative act that arguably could be subject to judicial review. So they examined that, and they said, well, in that case, all it was a backdoor effort by Air Canada to get at the previous issue that they had put before the court. They were really concerned about was it in the bulletins, it was something else, and the court ended up dismissing the judicial review application, but primarily there was both a finding that there was no decision or administrative act that was subject to review, and also that they weren't functioning as a federal board commissioner tribunal at the time, which was actually quite fascinating because their act is much more robust than the kind of act that we see for this private club. Their act actually granted them all kinds of powers and limits, etc. But even in that context, the court still drilled down and said, well, in this particular function, what are you doing? So that's kind of the background of the case, and the court helps us a lot by saying, and it's the same question I would pose in this case, did the Toronto Port Authority conduct described in the bulletin constitute administrative action susceptible to judicial review? So they're asking that question. Is there a decision? And so paragraph 22 of the trial, I would mark that off. The federal court judge agreed with the respondent's submissions, finding that no decision or order was present before him because the Port Authority's bulletins do not determine anything. But then the court went on, to flip forward to paragraph 26, that although the parties in the court, and this was sort of interesting, I don't know if it sort of matters in our case, but I want to argue this as fairly as possible to the position the applicant has taken and not try to be narrow, because I think we get where we want to go being as fair as we possibly can. So although the parties in the court focused on whether a decision or order was present, in substance they were addressing something more basic. Whether in issuing the bulletins and engaging in the conduct described in the bulletins, the Port Authority had done anything that triggered rights on the part of Air Canada to bring a judicial review. And I think we could say that should be the same question here. We could be cute and say, well, there was no decision, and we say that in our submissions. So
I think the case is pretty specific, that it doesn't just look at decision or order, because if we look at the decision in paragraph 24, the court states that it includes matters, it's much wider.
Yes.
In fact, it could be a decision, order, proceeding.
Exactly. Yeah. So if we look at it that way, and we're not going to, and not try to say to you it has to be a decision, we're saying that's fine. It can be a decision. The significance of a decision or order, if that's specific, is there's a time element, because then you have to bring the judicial review application within 30 days. What the court makes clear is, look, we're looking at a course of action. Whether it's a decision or order, that might have some technical impact, but otherwise, let's look at this. So that, and we would say, well, that's fine. Let's look at our case that way. Was there, using the language of the court, has University of Canada done anything that triggered rights on part of Mr. Jaffal to bring a judicial review? That's the question in paragraph 26. And we say that's the first question we ask in our case. You see at paragraph 27, they find that on the facts of that case, they didn't. Now, so I'll keep flashing forward to paragraph 28. The jurisprudence recognizes many situations whereby its nature or substance and administrative body's conduct does not trigger rights to bring a judicial review. And then at 29, it's one such situation is where the conduct attacked in an application for judicial review fails to affect legal rights, impose legal obligations, or cause prejudicial effects. Now, so there's where I would stop and look at it from the perspective of our case. So, first of all, did the University of Canada actually affect the legal rights of the applicant, or anybody for that matter? And we would say, quite simply, there are no legal rights that were put into, that were affected, by the course of conduct of University of Canada in this circumstance. and it's one of those hard ones because we're kind of racking our head to figure out what would the sort of analogy and what examples could we use. There just simply isn't a legal right that's been triggered. The person asking for University of Canada to do something doesn't have any legal rights vis-a-vis Universities Canada. Arguably, and the legal rights of McGill would be contractual rights based on the bylaws of the organization. There simply aren't any legal rights affected. And significantly, as we've seen, that this organization has no power to affect, particularly the applicant's legal rights. So the next one is fails to impose legal obligations or the language is awkward, but I guess we look at it this way, that there is nothing in the decision, so to speak, and I'll use that word in the vernacular, the decision or the course of conduct, that imposes a legal obligation on Ms. Jaffal or anyone else. So we don't have the affecting of legal rights, and we don't have the imposition of any obligations. Nobody has to go and do anything. And does it cause a prejudicial effect? And you'll see in this case, there's some reference to the prejudicial effect isn't the prejudice of the fact that this organization isn't doing what Ms. Jaffal asked it to do. It's just there is no prejudice to her legal rights or obligations, or to her at all moving forward. The actions of, or the inaction of University of Canada doesn't cause any prejudice to her in her existence at McGill University or otherwise. And it obviously, and the court's not speaking of the sort of mechanical prejudice of, oh, it would have been nice if they did what I asked them to do. It didn't lie with the University of Canada do what she was asking them to do, but the fact that they said, just please go to see the dean of students, doesn't then somehow prejudice her in her moving forward to the Human Rights Commission or any other body. And as the court points out here, it may be that other matters going on in her life and in her interactions at McGill are causing prejudice to her. And I'm not, for a moment, standing here saying that we've analyzed and tested all of the scope of allegations made against McGill University or our clients. And there could be something happening that may or may not be prejudicial to her. Might be, is I guess the best I can say. But just as the court observes, I think it's in paragraph 37 in Air Canada, there's a reference to the fact that legal rights might be affected, it's just not by this course of conduct. So what, I guess, is the next question. In the absence, for we would say that if you apply that test, you would come to the conclusion in our case that there is no effect on legal rights. There is no imposition of obligations. There's no prejudicial effect caused, and that's a circumstance. If you apply that test, you come to that conclusion, then you can say, oh, you know what? There is no decision or course of conduct that is triggering the right to bring a judicial review, just like in Air Canada. So, just to repeat my rhetorical so what, we've given you at tab H the decision of this court, Justice Snyder from 2013.
What page?
At tab H.
Okay, I don't have any tabs. Do you have the page?
Oh, I'm sorry, page 126. I understand. That's the downside of electronic filing. There's lots of upsides, but so it's at page 126, and I will take you to paragraph 14 in the analysis of page 130. And we've given you this case. I'll tell you what it's for, and then I'll take you to it briefly. But essentially, this was a case where a respondent went to the court and said, in the context of an application, there's no decision here, so can you please strike the application? So we put it in to sort of answer the so what question. So Air Canada tells us that there is no decision or course of conduct, and in this case we can see that this court sitting as a motions court has said in the past, oh, well, if you can show me that there's no decision and there's no right to judicial review, then it's appropriate to strike that out by way of a motion. And so that's very helpful because it's a recent case, gives us a very specific answer to what we can do here. So in this case, as I recall, a lot of cases running around my head, but there was an issue before the court, Justice Hughes, I believe, about the validity of a real estate transaction. And on a successful judicial review, he set aside the transaction and said that the government had to consult with the applicant. And so then they came to court later and on the second judicial review and said that we don't like the inaction of the government and that they're failing to consult. So there was an issue there about was there really a decision or a course of conduct that would open the door to judicial review, and the court for various reasons said no, they haven't done anything yet. You're premature. But what's helpful is just the language that we see at paragraph 14, that the test for striking for judicial review is high, or on an application. A motion to strike in the context will only be granted in the most obvious cases where the notice of application is fundamentally flawed, and we've given you the David Bull decision in our materials. But then it goes on, and at 16, having read the motion materials and heard the submissions of the parties and having directed my mind to the test for striking an application for judicial review at this preliminary stage, I'm persuaded that this is an appropriate case for striking the application. And then at 17, as a threshold requirement for every judicial review, an applicant must identify a decision that is reviewable. And in my view, they've failed to do so. And we would read, the word decision is in quotes, and we would read that, we would ask you to read that as per Air Canada. And so, but if you can't do that, then you're out. And it was interesting because it's somewhat apropos to our case. This can be best demonstrated by reference to the PFN's notice of application, where it states that. And then in the notice of application, it's a sort of a series of, you just didn't do what I wanted you to do. It's an application for review in respect of a decision made by the respondent to not consult or to adequately consult regarding these lands, or to not transfer the lands pursuant to our particular agreement, and to refuse to acknowledge our rights under its treaty, as well as Canada's failure to follow the reasons for judgment. So it's a kind of complaint, you're not doing what we want you to do. And in the end, the court concluded that, maybe I'll just take you to the thrilling conclusion at page 133. And again, I apologize for taking you so deeply into the cases, because I know it takes some time, but it will help us. So at 33, for the above reasons, I'm prepared to strike the application as an abusive process, and the overriding problem with the application is that it does not disclose a decision. I believe that certain of the other problems could possibly be remedied through amendments, and give some examples, but halfway down. However, the fatal flaw in the application is that there has not been a decision or action or failure that could form the foundation for a successful judicial review. The application is accordingly doomed to failure, wasting any more judicial resources on what would have become an exceedingly protracted battle, and that, for obvious reasons, is a risk in this case. Is simply not warranted. And so those comments will be apropos to some of the other arguments we made down the road. But as a simple proposition, at this stage, in answering the question, was there a decision or course of conduct? No, there wasn't. And if there isn't, we would submit to the court that it is appropriate for this court at this stage to strike the application.
Just to get a sense of timing, how much longer do you think you're going to be?
Maybe half an hour.
Okay.
I'll be mindful of it. I'm not sure. Well, perhaps you could help me. I know that we were scheduled at a particular limit. What is the court's inclination in terms of the time available today? Because I'll obviously should try to work to your.
Okay. Well, I'm not sure exactly if there's anything going on in this courtroom afterwards.
Well, I'll be mindful, and I will make an effort, because I think having gone through the background, having gone through some of the cases, I'll be mindful, and I can give you some of the pinpoint references, not necessarily take you to.
Okay, no, I I don't want to rush you. I just want to have a sense of how much time so that we're fair.
Okay, so the second question is, was Universities Canada acting as a federal board commissioner tribunal? So, because as you know, even if there seems to be something that could be subject to review, you still have to ask, was the person, because it could be a private golf club, a synagogue, a church, some other kind of civic group, and that doesn't mean you've got to go and have judicial review of what they did. It's got to be, in this context, federal board commissioner tribunal is contemplated by the case law. So I'm going to take you back to Air Canada. Sorry, the tab C is not helpful to
Page 43.
Page 43. Exactly. Yeah. So again, the case makes it, as we see in paragraph 44, an application for judicial review under the Act can only be brought against the federal board commissioner or other tribunal. And it's very clear under the Act, and at paragraph 47, the court makes it clear that when we're looking at this, it's not just is an entity established under an act of parliament. The issue at 47, the requires to examine the particular jurisdiction or power being exercised in a particular case and the source of that jurisdiction or power. So it's not, you don't just say they were established by an act. You've got to look at what they were doing and think about this. So paragraph 48 reinforces that the case turns on whether there's a particular federal act underlying the power or jurisdiction being exercised. And what was interesting is, in this case, the Federal Court of Appeal accepted the respondent's argument that the power being exercised must be of a public character to be susceptible to review. And you can see that at paragraphs 50 and 51. So in essence, the court, in going through and saying, well, it's got to be this, if you're going to got to be Federal Board Commissioner Tribunal, if you're going to trigger this, and then you've got to look at the statute, and then you've got to find a power that's being exercised that's public and not private in nature. And in our case, as it turns out, that analysis helps because it leads us to the conclusion that we're asking to come to. Then if we go to paragraph 60 of the case, the court then says, all right, having said it's a bit elusive, but what the court did was provide a series of bullet points on the ensuing pages which describe relevant factors disclosed by the case law that help us unpackage whether something is public or private. And so what I propose to do is to take you quickly through the bullet points and relate them to our case. And then what I might do what I'll do after that is show you what they did, because I can do it, but then the Federal Court of Appeal does it in Air Canada, and you can see that the way in which they do it is very consistent with the kind of approach we would urge in the court in this case. So the first bullet point is effectively, is it private? And I've spoken of that quite a bit, and suffice it to say it's our position that what's happening here is the exercise of discretion by an organization in a very entirely private context. And I think that's fleshed out more and more as we go through the other elements. The sort of nature of it being a private organization, it insinuates itself in almost every one of the bullet points. So the nature of the decision maker and its responsibilities, and the court says, is the decision maker public in nature, such as a crown agent or a statutorily recognized administrative body charged with public responsibilities? And is the matter under review closely related to those? And the answer has to be, in our case, no. It is not. It doesn't meet any of those. It's not a crown agent. It's not a statutorily recognized administrative body. It's not charged with public responsibilities. And the matter under review is not related to anything like that. So the next bullet point is the extent to which a decision is founded in and shaped by law as opposed to private discretion. And later down in that paragraph, it reads, matters based on a power to act that is founded upon something other than legislation, such as general contract law or business considerations, are more likely to be viewed outside of the ambit of public judicial review. And that's what our case is. That it's an entirely exercise of discretion. There are no limits to how the Universities of Canada would do its business, other other than to do so in accordance with its bylaws. And so, again, every bullet point basically militates in favor of a finding of a private act and not a public one. Then the next one, the body's relationship to other statutory schemes or other parts of government. And is it woven into the network of government and exercising its power as part of that network? And, well, it's entirely the opposite. It's a lobby, amongst other things. We see it in the register of lobbyists. So it's not woven into government and pursuing and exercising its duties in that context. It's on the outside of government and asking government to do and take certain steps, amongst other things. The next bullet point, extend to it that decision maker is an agent of government or is directed, controlled, or influenced by a public entity. And so when you go down at the bottom, that requirement that policies, bylaws, and other matters be approved or reviewed by government may be relevant. That's not the case.
So there's no form of government review on Universities of Canada?
As I say, it's Universities of Canada is a private club. It's right in the statute. You're governed by your bylaws. And then they raise the point of suitability of public law remedies. And we would say in this particular instance, you can tell they're not suitable in as much as the remedies requested by the applicant aren't really public law remedies. They're very much civil remedies, and which I think speaks to the issue that this isn't that doesn't help decide whether we're public or private. The next bullet point, the existence of compulsory power. So it's, as I say, this sort of insinuates itself throughout. And in the last line there, the compulsory power, this is to be contrasted with situations where parties consensually submit to jurisdiction. Well, all the members of Universities Canada are voluntary members. Not like me. I'm happy to be a member of the Law Society, but I better do it or else. And then they cite this exceptional category of cases where the conduct is seen a serious public dimension, and somehow we have to look at it. And we would say, well, it's a temptation to say, well, that should be a throw-all category. But it's helpful in the Air Canada case. We're dealing with aviation. We're dealing with thousands of people coming in and out of one of the busiest sort of private or small terminals in the country. And the court's not equating that kind of, even in the Air Canada case, we don't have this level of public upset. It didn't trigger the exceptional category, and it wouldn't in our case. We would suggest because it talks about very serious exceptional effect on the rights or interests of a broad segment of the public. I think that's and so it's not contemplating where you have individuals or groups of individuals having a kick at a university. And I think that you'd have to read, even if there was some temptation to think, should we use this catch-all category? You'd have to look at it in the context of all the other bullet points and realize that this isn't where this kind of case could possibly belong. It could be that Ms. Jaffal has a legitimate case before a human rights tribunal. It's not. So one, in contemplating the exceptional category, I think has to think about, well, if there's not really a decision or course of conduct, this is clearly a private enterprise, and it's not risen to the level where we're going to protect this broad segment of the public, so we better stay away from that. And I would ask you to sort of have regard to what the Air Canada case says about that, because in that case, I think you could have it, and again, because we're dealing with aviation and a large segment, and the court's not even tempted to go there. It's just, no, this isn't that kind of a case, and I would suggest that this is not either.
Just before you go on, the last portion of that paragraph states, this may include cases where the existence of fraud, bribery, corruption, and human rights violation transforms the matter from one of private significance to one of a great public moment. There are allegations being made by Ms. Jaffal that this is not just limited to her, but that there would be a component regarding international students, if I understand the material.
Yes, and I say, and that's why I say the temptation. So, first of all, international students, it's not international with respect. It would be a small segment of students. We've been talking about the international students at McGill University at best. And I think to be a fairest reading would be the international students in the department in which she functions. If one were to give the fairest reading to her materials, and we would say, well, we're not talking about a broad segment of the public in that context. And then is it one of a great public moment to imagine? And then when we're talking about that small group and talking about these allegations against McGill University, because that's the other the problem here is we're conflating McGill with Universities Canada as well. And that's one of the challenges of this kind of the way the application's been formulated. So it would be, in our mind, in our submission, a very inappropriate reading of the test in Air Canada to say that Universities Canada is engaged, of course, of conduct of saying that, because you have to sort of look at what they're doing, and if what they were doing somehow had some, like, related to the things that McGill was doing, then I don't think that this would take you there, but you could at least have the intellectual discussion. But you have to look, we're looking at all these bullet points vis-a-vis Universities Canada, and all of them militate in favor of it being a private organization. And then what we're talking about here is something so remarkable and so broad, but it still would have to be related to Universities Canada. And even the allegations, which I'll take you to in a few moments, of fraud and bribery and these discriminatory policies relate to McGill. And so the decision of Universities Canada is it of moment that's affecting a broad segment of society. Well, its decision is, arguably, using the word decision in quotes, was, look, we can't do anything for you. Please go see the university or some other place where they can, and we're not going to engage whatever we have available to us to do anything for you. I would ask you to look at that, and it's that course of conduct that you have to look at to say, well, does that affect a broad segment of the population? Does that impact on the kinds of issues that are here? And is it such a serious public moment that University of Canada is saying, within my private conduct, because it's clear on all the bullet points at that point, the University of Canada is functioning way outside of what was contemplated under the Act, and not functioning as a core commissioner tribunal. And then we have to look at the conduct, and that's it starts in exceptional category of cases where the conduct has attained a serious public dimension, I guess, and that's what we'd ask. Please don't. We would, our client's employment court, please don't tie it into these series of allegations that are, with respect, quite reckless and unsubstantiated when we get to the materials in due course. But don't tie us into that and trying to come to a conclusion as to whether or not we're a federal board commissioner tribunal, particularly in light of the fact that on every test leading up to that, every single bullet point tells you this court clearly we are not. So when we get to that point, to trigger that exceptional category, we have to look at the conduct of Universities Canada and then ask whether that conduct was impacting on a broad segment of the public, and was it of such a serious moment. We would say to you, how can it possibly be? We're simply saying, we're a private club. This isn't where we get to decide what we put our nose into. This isn't part of what we would put our nose into. So please, please go someplace else. That conduct, when it talks about conduct, we're not McGill University. So that, I don't know if that helps at all. And so what I would, in the interest of time, I would then simply ask you to note at paragraphs 73 through 80 of the decision, you will see where the court addresses the facts of its case as against these bullets. And I just think it's helpful because it helps reinforce to me any doubts I had when we were looking at what did the court mean when it's looking at these relevant factors. And it talked about how it's where the lack of discretion, or sort of the fullness of their discretion, and lack of direction from public bodies, etc. So that may have been. So I'm just, to the extent that you'd like to see how the court did it in that case, those are the paragraphs. So what we're asking the court is to conclude that the University of Canada is not exercising any sort of public authority or jurisdiction as to permit a review. And again, we provided you with, in addition to the Pegwas case that I took you about, so from a procedural standpoint, we would say Pegwas would say, just like if there's no decision, if there's no federal board commissioner tribunal, it's appropriate to strike by way of a motion. But we've also included I was going to say Tavis Chain K, but I'll give you the page references. At page 155 and page 160, there's the Menace decision at the Toronto Division Court of Appeal. And I won't take it. They're dealing with, from time to time, this court has to deal with some interesting litigants, I'll put it that way, and Mr. Menace was upset that the court had made a direction that he wasn't allowed to say bad things about the court in the record. But in any event, in that case, in Menace, the court was dealing with precisely the issue that we're putting in front of you in the court, and the court found that if there is no federal board of commission and tribunal, then it can, and the court satisfied, then it's appropriate to strike the application on motion, and that's what happened in that case. So that takes me to the last piece, the frivolous and vexatious allegation that we make, or attack, maybe to better put it, which starts in the record at page 14. So 14 and beyond in our written representations. What I'd like to do is take you, there's two cases that can help. It's a very, we're saying that there's kind of, that the application vis-a-vis University of Canada is frivolous and vexatious according to the test in the cases on kind of two fronts. And I'll flash forward a little bit, which may or may not help me be more efficient, but on two fronts. And one is it's replete with all kinds of allegations that are very dramatic, very serious, and are not made out in the materials. And so that's sort of part one, is we can characterize what those are, and what they're not is an intelligible narrative that could possibly lead to a legal conclusion. But the other front, just so that you have in head where I'm going, is that another way of saying that something is frivolous and vexatious is to say that it cannot lead to a practical result, and therefore it's an abusive process, or it's frivolous and vexatious, it can be struck. And by that we're going to be saying, well, look, the relief being sought, putting aside everything else we say, the relief being sought, this court can't provide and ought not to provide. And so even if we get to that point, then you can't get to a practical result, because the court can't do it what Mr. Jaffal is asking it to do. And that's another basis on which the court has said, yeah, sorry, but we should strike. So with that kind of foreshadowing where I'm going, I'd like to take you to Steiner, which is at page 166, and the decision of Commissary Hargrave. And I just quickly, paragraphs 8, 10, 16, and 18. So to the extent that you have a record of what I referred to. So 8, turning to the second ground on which the defendant seeks to have the action struck, and the rule that it cites as the precursor to the one that we're relying on, that it's scandalous, frivolous, and vexatious. Such an action is one in which the claimant presents no rational argument based on evidence or law to support the claim, and indeed it's an action without reasonable cause which will not lead to a practical result. And at 10, it goes on, an action that is scandalous, frivolous, or vexatious may be struck as an abusive process of the court, for the court has the jurisdiction to protect itself from the abuse of its process. So that's kind of, if we accept our submissions, that should happen. And 16 and 18 are just helpful because it sort of breathes some life into how do you define. It's obviously very amorphous and difficult to define exactly, and whether in the superior court rules or the federal court rules, scandalous, frivolous, and vexatious is hard to define, and people get very excited about those that kind of language. But 16 and 18, it's helpful. A scandalous pleading includes one which is improperly cast a derogatory light on someone with respect to their moral character. The claim is frivolous, where it is of little weight or importance, or for which there is no rational argument based upon evidence or law in support of the claim. A vexatious proceeding is one that is begun maliciously or without a probable cause, or will not lead to any practical result. And 18, the pleading as a whole is insufficient on its face to not present a rational argument, either on evidence or on the law or in support of the claim, but merely complains of investigation, which I point out was not unreasonable, given the circuit goes on to cast unreasonable aspersions on the Crown Counsel, and as such the claim is frivolous, and because there's no cause of action, it doesn't lead to a practical result. In any event, it was struck in that case. So I'm hopeful that you'll find some of that language helpful when considering the argument that we're making. The next case that I want to make sure that you have in your mind when you're thinking about this is at page 171, which is a more recent decision of Propriétaire de la Fermière, and dealing with a challenging litigant. And if we go to page 172 in paragraph 2, there's some helpful language in this case that helps us understand what we should do with these kinds of cases. So paragraph 2, a pleading may also be struck in the middle of the paragraph on the grounds that scandalous, frivolous, or vexatious pursuant to 221C, where the pleadings are so deficient in material facts the defendant cannot know how to answer. And then it goes on, the next paragraph 3 at the end, however, the court need not accept, and this is accept at face value, bare allegations, factual allegations, which may be regarded as scandalous, frivolous, or vexatious, or legal submissions dressed up as factual allegations. The allegations set out in paragraph 84 in the 84-page pleading are for the most part unintelligible and consequently difficult to summarize. And the court struggles with that. And then continues at page, I'll take you to paragraph 10, page 174. And here the court's noting with approval, Alberta case needs, struggling with these kinds of pleadings when faced with truly baffling OPCA materials. And this court may be aware that is an acronym for particularly troublesome kind of litigation that sometimes appears in court. But in this case, in the Bashir case, the court said we can look at this kind of at pleadings that are very difficult to follow as being analogous to what the court faced in the OPCA kinds of litigation. When faced with truly baffling materials, a court may take the approach applied, and I don't intend to try to capture that name, and strike a proceeding based on incomprehensible arguments and allegations where the defendant is left both embarrassed and unable to defend himself, and the court faces a proceeding so ill-defined that it is unable to discern an argument or identify any specific facts. And it goes on to say, although not an OPCA claim, this proceeding is based on similar incomprehensible allegations. And then at paragraph 12, it talks about how to deal with that challenge. And in 14, the plaintiff's action is fundamentally vexatious and abusive of the system. In circumstances, no useful purpose would be served by making a determination on the issue whether there is jurisdiction in this court to hear the matter, there being neither a possibility of curative amendment nor any indication that this action could be instituted again in an acceptable form. The plaintiff's pleading should be struck without leave to amend. And so it's sort of awkward, but I wanted to take you through those two cases because it kind of takes me back to my sometimes successful but always unsophisticated argument that if it looks like a duck and walks like a duck and quacks like a duck, it is a duck. And in this case, that's the duck in this case is exactly the kind of litigation that was referred to in both Steiner and Bashir. And the pleadings are rife with allegations of conspiracy and slave labor, exploiting students, abuse of students' work, discriminatory policies, discriminatory funding, and but there's no evidentiary basis when we look at the application and look at the affidavit. There's nothing to support bald allegations. It's just bald allegation after bald allegation. And what's included in the exhibits is either a repeat of the narrative in the application in 2 or 3 instances, or the other 40 some odd exhibits are simply copies of things like checklists coming from other organizations, Universities of Canada or some other place. They're just neutral documents that talk about general issues relating to education. There's nothing that would support. There's not chains of emails. There's not other statements from other people affected. There's not the kind of document. There's not even funding documents. There's the kind of evidence that one would expect to find, keeping in mind that if you take the application together with the affidavit, that's the case. There's nothing that supports anything other than reckless, bald allegations. And when we look at the cases I took you to, all of the descriptive language applies. Deficient in material facts, bare allegations, unintelligible, baffling, embarrassing. And I mean, there's terrible allegations made as against McGill, and some not pleasant ones made against University of Canada, and they're embarrassing in the legal sense because they don't come with anything to back it up. It's just somebody being allowed or taking to just put words down on a piece of paper without taking the responsibility for somehow organizing them in a way that meets some legal test and has an evidentiary basis for making them. They're completely, to be with the greatest of respect, for the most part, the application itself is completely incomprehensible and ill-defined. You cannot read through it. Whether the court can't do it, and certainly my clients can't, and understand the nature of the complaints as it relates to them or at all, and what they're supposed to do in response to it. And so we would say if you accept that characterization, then it does, then this pleading, and even taking into account the affidavit, is frivolous, vexatious, and scandalous as characterized in the cases that we've given to you, and on that basis should be struck.
Now, would that criteria apply, because the cases that you've cited dealing with the availability of a motion to strike a judicial review application, would this frivolous criteria or ground also apply to a judicial review application?
I'm trying to remember. We would say it would apply with equal force, just as because the court's made it clear that striking even, like for example, the earlier cases I provided to you, the court concluded on that using the Bull test, or that you can strike an application under the broader section, certainly for the grounds of no decision or as disclosing no reasonable cause of action. But the court in those cases also, in a couple of those cases, I'll bring them to you in a moment, I believe it's a live issue, both either under the frivolous, vexatious, or the abusive process. And the court's coming to the same conclusion. So procedurally, if that's your question, is it available to the court to strike an application, just like it can do it for failing to disclose a cause of action? Can they do the same thing for frivolous and vexatious? I would say yes, and I believe is it. So I just have to go back to the. I'm just flipping back because I believe in Peguis it was a live issue under, for example. So in Peguis, for example, the court, so at page 133 in the conclusion, at paragraph 33, I'm prepared to strike the application as an abuse of process, and I raise that because in this case the court was dealing clearly contextually with the Rule 221, but then didn't. Just struggled with the issue in this particular instance of whether there was a decision. But by using the language of the abuse of process, I would submit it's using 221 writ large, and that's whether, so A is the no reasonable cause of action, C is frivolous and vexatious, and I think it's D is an abuse of process as well. And I think that the answer lies in that yes, the court, if it meets the test, that it's a direct possibility of success, etc. Then it would apply with equal force to whatever provision we're looking at. And I think that's the case under Menes as well. I just feel like the court looked at it as sort of both under the minutes, I think it was limited, so, but I'll come, perhaps after a break I can come back. I think there's a couple other cases, but for sure, in the context of how the court looked at it in Peguis, that language of abuse of process, I would say, would open the door to it applying with equal force, whichever version you're looking at. And the logic, too, because when you read the exception that's set out in the, I wanted to say the Bull case, but I'm not sure if I'm...
Okay, well, you can have a look at it during the break, and you can let me know.
All right, so the flip side of that is, so we're saying that sort of incomprehensible nature of the pleading opens it up to one that should be struck. The other side of that coin is the no practical result. So in the cases we also saw, well, it's not going to lead to any practical result. Then there is an opportunity for the court to cut it off. And so I took you through the beginning what Ms. Jaffal was asking for, and in our written submission at page 11 of the record, I believe. Sorry, that's page 15 of the record. It's confusing me. Actually, representations. So we deal with this issue of at paragraph 43, we characterize some of the things, or basically what she's asking for, as best we can. We saw how difficult that was when we actually looked at the text. And at paragraph 44, we've set out what the court may do on an application for judicial review, and I don't tend to take you to that. I'm sure you read those paragraphs. I would if I was a judge in this court. I'd be very familiar with what my power was. But the court has a limited power prescribed. It's clear to do certain things. We've provided you with some case law relating to the issue of damages. I don't know that there's any particular dispute or issue in the court about the scope of the powers. I think that it's the easiest way to deal with them in our case. As I say, we've got a couple cases here about how the court can award damages. The easiest way in our case is just to say, look, this court is not empowered to order the kind of investigation, the kind of damages, the punishment, to tell us to throw McGill out of the University of Canada, to get into supervising a system to prevent slave labor. And I'm saying that sort of too quickly now, but we've gone through it painfully at the beginning. I can't find authority that says that this court can't do those things because it just isn't done. I mean, other than there is discussion around damages, for example, and some other general discussion about the scope of the powers, but this court, in our submission, doesn't come close to. It just isn't what happens in judicial review. The kind of public remedies available at Sahar and then damages, etc., don't open the door to the court doing the sorts of things that Ms. Jaffal has asked for in this case. And, I mean, the idea of the court supervising a system that would prevent slave labor, and not only that, all of the relief that's been sought presupposes the transgressions on the part of not University of Canada, but fundamentally on the part of McGill that are outrageous and just, well, outrageous and preposterous, but also heinous if true. And the court's not going to get to, it is never going to be in a position to go and send somebody off to stop slave labor without having somehow embarked on a massive inquiry to determine whether that was happening in the first place. Never will.
I get the point.
Okay, so the result is, this is a case like Steiner, like Blackshear, where striking would be appropriate to save University of Canada from having to try to be embroiled in this litigation, and which with respect is somewhat incomprehensible for who knows how long and at what cost. And so, as I said at the outset, University of Canada is imploring the court to strike the application under any aspect of 221 for the reasons that we've said. I just as a sort of a bullet point reference, I won't take and read the language now, but there's sort of dramatic effect if you could look back at Peguis at paragraph 33 and Blackshear at paragraph 10. There's sort of the statements of the court that I think I've taken to you already are impactful when we've gone through this analysis, and they kind of give a direction saying, boy, this shouldn't be there. This case just can't go forward because of the problems that the unjustified problems that it's going to cause for this particular respondent. So thank you for your patience. The one thing I'd like to leave with you is I do have a summary sheet where we've taken from the application and the affidavit as many of the kind of dramatic allegations that we could find, and with a reference to the page. And I think I wanted to leave it with you because it's difficult. We've sort of characterized off the cuff saying that the materials say this, and this. And I think it's important that you're able to go and see, okay, I can see where it says this and at what page it does. And we've simply used the language from the application document with the page reference. So there's no, the document that we're going to provide to you doesn't have any, not that it would be appropriate, but it's not argumentative or...
no, but it could be construed as expanding on your factum.
It could be, well, and if you're not comfortable with it, that's fine, but it's kind of a cheat, because otherwise I could... The other temptation would be to take the time to take you through each of those, and so that I'm not just loosely saying to you that this is what's in the materials.
Well, at this point we'll see if the applicant has an objection to that.
Do you have any objection to our leaving this with the court? And as I described it, these are statements that are extracted from the application and the affidavit with page references.
I cannot say if I have objection or not until I read it, and I need at least little time because English is not my first language.
Okay.
So I don't know what is the procedure.
Do you have any more submissions to make?
I do not, subject to any questions you might have.
Okay. The only question that I have is with regards to the party that's the subject of the judicial review.
Yes.
I noticed from the application that it's taken against Mr. Paul Davidson, and the brackets show that he's the president of Universities Canada. Is it my understanding that you're not taking objection to the party that's subject to whether or not this can be done? I just want to make sure that I understand.
Again, because we're dealing with an unrepresented litigant, we try to be as fair as possible without jeopardizing our client's interests and not come before you with motions that will perhaps waste time. So we've said in our written representations that we understand when we read the way that if you read the application as a whole, the affidavit and subsequent correspondence, we can see it was intended to be. And Mr. Jaffal said that there was an and missing. I don't think that's entirely fair because the and wouldn't if you put an and anywhere, that wouldn't really make sense still. I think it was that she meant to say at the end, and University of Canada, we're prepared to argue it that way because we don't really want to have a motion and then ultimately come back and we just want to deal with the issue.
Okay, and I guess one more question. In terms of costs,
Yes.
if you are successful on your motion, you're seeking costs?
We are.
Okay, and do you have an amount?
I don't have specific, and maybe I should say that slightly differently. I don't have specific instructions as to whether or not we're seeking costs.
Okay.
If it please the court, that's something that I could talk to my client about, both in terms of whether we are, and if so, in what amount.
Okay, thank you.
And I'd be happy to address that either later today or in
writing.
reply. In reply or in an appropriate in writing if that's more convenient.
Okay, so if we can, we're going to break for not more than 10 minutes. I expect you to be back here at 20 after 11. Okay?
Thank you. Order.
have like a printed hard copy for every exhibit separate. So I have these files, so I want to submit them, please.
Okay. You don't have objections to the binder?
These are the same, but I did not bring like the exhibit printed separately from.
So I'm sorry, but you have a binder that has copies of the exhibits in your affidavit?
Yeah.
Okay.
Yeah.
If I understand correctly.
Yes.
Yeah.
They are same, but I did not like bring to hand, so I want to read something and just in case if you want to follow with me.
I'm not sure I'm following.
Yeah, I mean like I want to read from the exhibit. Yeah, so if you don't mind, like I can read, but it's easier when you have a hard copy.
Okay, and you only have one hard copy?
At this time, yes. I have the other one, but it's not. It needs more than one.
Okay, and you're proposing to
I have
read?
the second one, yeah, but I need to just put them in separate folders.
Okay, well let's begin with your submissions, and when we get to the documents, we'll see how we manage if it's feasible.
Okay.
And I will ask you to speak up because there's a bit of a back sound.
Thank you. So I will start by my response to the rules and the grounds that the respondent are relying on to strike my application for judicial review. So the respondents, they are mentioning that they want to strike the application for judicial review mainly by rules 221A and C, and by objection if or debating if Universities Canada is included in the definition of the federal board or commission or other tribunal in which the federal courts have jurisdiction to be involved with. So first, I will start with the definition of the federal board, commission or other tribunal. It is written that it means anybody, person or persons having, exercising or purporting to exercise jurisdiction or power conferred by or under an act of parliament. So,
you're reading from Section 2 of the Federal
yes,
Court Act?
Yeah,
okay.
Section 2. So this is like conferred by or under an act of the parliament. I did not like understand the difference when the lawyer mentioned the lobby and act of the parliament, but it is established by an act of the parliament. Maybe I did not read the act or like maybe there was no mentioning for the ground that the act established it, but for any organization is established, the ground that they put it in the website and they are saying we will do this, A, B, C, these are considered the ground that or the basis for the organization in which it was established for. So this is what I consider. And for the other part is that when I sent the application for the respondent, I received a letter in 10 of June from the lawyers mentioning that we intend to respond to the application. And they define themselves as they are lawyers for Universities Canada. So if, as they mention, if there is no jurisdiction for the federal court in this matter, they could have asked immediately in 10 of June for a motion to strike and not wait till I submit my affidavit and exhibit in the beginning of July. After that, they started to look for a reason to apply the motion to strike, and even they did not refer to the exhibits that I mentioned, and I will talk about the exhibits. So here I will read Rule 58, Section 2 from the Federal Court Rules. It is when motion to be brought. 58, Section 2. When motion to be brought. A motion under subsection 1 shall be brought as soon as practicable after the moving party obtains knowledge of the irregularity. And the rule is telling shall. It does not say may. Some of the rules, like it say may, and it can lead to debate whether can be or not. But this rule is say shall. For that they cannot, like from my point of view, like let me wait all this time, then they add or debate in the inclusion of Universities Canada whether it is like under the jurisdiction of the federal court or not. And it is written, it is established by an act of parliament. So I consider that the true grounds that I will talk about them that were in the old website, these are the grounds under which the act of parliament established Universities Canada. So, and in all cases, this is when motion has to be brought. So, since they did not bring this debate immediately, so it means they did not consider it as a regularity from the beginning. So I don't think that this ground can be taken into consideration. So this is the first one. I put a page in the record when they are mentioning in their website the governing structure of Universities Canada. We are non-governmental, non-for-profit membership organization established by an act of parliament. So this is also like a confirmation. So I put a document. So it seems I recognized immediately when I got the response from the lawyers within 17 days that they want to apply for a motion to strike, that they did not read all the exhibits or did not read them carefully, especially the most important exhibits that are related or that show that Universities Canada has the power to interfere within the ground that they are wrote, and that I have the proofs. So, and I will mainly refer to Exhibit B, C, D. These are like, it has a lot of documents and a lot of proofs, and if I will go through them in any hearing, I can confirm for the judge that it will break the agreement between Universities Canada and the agreement that I will talk about for good practice and other associations, because it is very clear. Exhibit B, C, D. And I B, yeah, C, D. And okay. All of them include exchange of emails, and I put the slides before every email in which every person can have an idea before reading the email.
Okay, the only difficulty that I have is I don't have these exhibits. I think I'm going to, if you're intending on referring to certain exhibits, I'm going to need to be able to see them.
Yes, so I have here hard copy. I can separate them, but they are a lot. Like in this exhibit, there are 251 pages, but I print them in, these are the emails, for example, exchange of emails with my team. Mainly, Honor, this exhibit and the issue that I wanted to talk about, it will take at least, in my opinion, like 3 days to go through them. But it shows very clearly that
okay. I understand. I just want to make sure that we understand the purpose of today's motion.
Yeah.
you have brought an application for judicial review in which you are seeking certain relief. The respondent has brought a preliminary motion asking the court to strike your application for judicial review. We're not looking at the merits of the application for judicial review. We're looking at the purpose. What I need to do today is to decide the motion to strike your judicial review application. I'm not here to decide whether or not Universities Canada had an obligation to do what you're requesting.
Yes.
I'm looking at that, and it's a preliminary motion. So I don't want to have the impression that you have to prove a case here, because that's not. You can establish that the grounds for the motion to strike are not founded, that your application for judicial review is not frivolous or vexatious, or that you have a reasonable cause of action. That's what you need to address for the purposes of today's hearing. Okay?
Yeah, exactly. So I understand, and for that I thought I cannot go through them exactly, but maybe I should read for the rule. I will start that they are, the lawyer mentioned that it is like it does not have, it is scandalous, frivolous, or vexatious. And he mentioned a sentence that even there is no proof or there is no exchange of emails. So I just refer to this to show that I have exchange of emails and the proof to what I wrote to University of Canada, in which I will read now. And then I will refer to another exhibit in which I have exchange of emails with University of Canada, clearly that there is a decision.
Okay.
So this is to show. So this is because he mentioned there is no cause of action and no reason for the motion to strike. So in response to this one. Now I will go deeply for them, but then I will read the letter that I submitted to University of Canada. The lawyers mentioned Rule 221A states that the motion can be struck if the pleading discloses no reasonable cause of action or defense, as is the case might be. So maybe. So I will show. So. Start now with exhibit AG that show. Now I will talk about whether there was a decision from University of Canada or not, whether there was exchange of emails, and whether like there was a cause of action or a reason for me to apply for this judicial review. Exhibit AG, page 714.
Just so that I understand where you're going, as the respondent has set out, or the defendant has set out, one of the arguments that needs to be addressed is whether or not there's a decision, order, act, or proceeding that's the subject of the judicial review, and this is what you're going to be pointing out to me.
Yes, okay. And not only there is a decision, there is also like hiding for who is responsible for the decision. Like I can refer to page 1 of the exhibit when I submitted the email. please forward this confidential email to the president, and one of them is the Honorable Paul Davidson. First, like I mentioned, and this was in 3rd of March. So it was confidential, and then it was directed to the Honorable Paul Davidson. So this is the start of sending the email. Till now there is no decision. And I can go through the letter and the grounds that I wrote for him, but I will go just in a chronological order to show what happened. So that was in 3rd of March. And I did not receive any response. So at the end of March, I sent again the same email with documents and the grounds to more than one email of the people members in Universities Canada. So this email is shown in after the letter, my letter. It's dated 31st of March. I wrote, dear all, I called early in March by
Which
phone.
page are you referring to? Do you know?
It starts with request, please. Or I can go starting from the exhibit. I will mention it briefly, then I will go fast after reading the letter in...
I just need you to identify clearly, because obviously we're not working from the same documentation, and if I'm going to be able to follow you along, you need to identify where these documents are.
Yeah. Because exhibit AG starts from page 714. Yeah, so this is the one, the first email. Then
Yeah,
I
the
will
first
go,
email that you pointed out,
yeah. Then the letter that show the ground, but I will go
that's
now.
the letter of the 3rd of March.
Yeah,
That's the letter that comes after.
yeah.
Okay.
So I can go through the letter, but before I go through the letter, I will mention briefly what happened. So at the end of March, in which the email will appear after this letter, I sent emails to many members at the Universities Canada, and I mentioned that I submitted a letter and did not get a response. And I was able just to meet a lawyer in legal aid for a brief time, and she told me it is not like I don't find a reason why nobody at least acknowledging the receipt of the email or the documents. So from this action, for any organization, if the person sends a request within the grounds of the association, there will be no sort of this like hiding or trying to ignore the email. I imagine myself, if I am responsible for an organization and somebody submitted for me something that I am not able to do, I will immediately write a letter with my signature and with everything. So when I did not hear anything from the members, I sent by email a demand letter to the Honorable Paul Davidson, telling that I suffered from McGill, and I mentioned all the grounds. So, of course, I'm not sure if who is receiving the email directly, because in many associations, the president or any person who has higher position, president or chair, they have somebody who can receive on behalf of them. So I cannot judge who is responsible. But after I submitted this, the website and all the grounds that I will go through in the letter has been changed. And mentioning in the new website, we changed the name of organization with the new look. I don't care about, for example, changing the name, but the new look, They deleted many of the words. They deleted many of the grounds to show that they don't have the power to interfere. And from that time, the issue continued, and when I sent the letter to the Honorable Paul Davidson by registered mail, I wrote a letter to the receiver that the signature at Canada Post will show who received the documents, because at that time, if I was able to have the members for cross-examination or examination, I can know who is responsible for the decision. And I took a video. The video is in the USB, and this is what I requested permission to show. I took a video for everything I put in that envelope. The date, and I am talking in the video that I am putting this paper, I am putting the CD again, that has a lot of the proofs against my case, and I am putting it in envelope that's protected, and again I put a USB in addition to the CD, so that there is no excuse that the CD has been broken or not. After that, there was no action. So
what is it, though, that you are arguing is, and I want to make sure that we understand each other. I'm not deciding on what the result is going to be when I ask these questions. It's because I'm trying to understand what your argument is and what your position is. I understand from reading the materials that you have an issue with McGill. You've complained to Universities Canada regarding some of those issues. Now, you are seeking judicial review against something that Universities Canada did or didn't do. And I'm trying to understand, and I want you to clarify what it is exactly that you think Universities Canada did or didn't do. That's the subject of what this court is going to have to look at. Not today, but further down the road if I don't grant the motion to strike.
Exactly. So this is the issue. The issue is that why I go through this way. This I just mentioned that their way of dealing with the issue. For example, which does not show the respect. But the most important for me now that to show that there is a decision, that they refuse to interfere. When I say yes, this is a decision. When I say no, this is a decision. For that, there is a decision. Since there is a decision, it can be reviewable. So I will go through the letter, then I will go through the email of the members of Universities Canada, 2 emails in which they mentioned that they will not interfere.
Okay.
So I will go starting from page 717, in which I mentioned the ground 1.
Okay.
For the interfering. There is a checklist for good practice from the joint statement that was signed between the AUCC, which is the previous name of Universities Canada, and many organizations. These are like international organizations in which this checklist for a good practice, and a good practice for whom? For the universities and the member of the universities in which Universities Canada give them membership. They give them membership based on these grounds. So, the first point in the checklist is accessibility. There is a question: does the institution enhance access to its program and courses by offering support to its qualified students with financial need from the host country or other country, Of course, I wrote what is there, and I can prove it with clear evidence that it was not. But the issue is nobody wanted to look at what I have, and nobody wanted from University of Canada to look at the grounds that they wrote. And all of that was clearly in the old website. They preferred to send, they refused, and this is a decision that can be reviewable, and they started to waste time and look for excuses, collect excuses to just bring a motion to strike. The second point is the transparency. Does the institution maintain adequate, appropriate, and clearly stated procedure for student appeal and grades and academic policies and decisions? I have all the proofs. I did not write this without having the proofs. And there, in one of the exhibits also, it was shown that a story of a student who went through the same situation, in which when the grievance has a proof, everything is suspended. For 3 months, 4 months, they want just the student to lose the proof, come back and lose the proof and cover. And that's what happened with me continuously for 4.5 years. So I have all the proof. Exhibit B is enough to show University of Canada, if they try at least to ask. So I was not, I expected from the president or the chair, for example, when I write a letter, not to take a decision immediately, not to take a decision for all what I requested. At least for me, I expect if I am a chair or a president to be responsible. I promised I put this to this. I need to meet the person, as you are hearing me now. So this is, I think, like everybody is judged, but at the position in which they are holding. So, but this did not happen from University of Canada. So there was a decision that can be reviewable because it is not within the ground. And the other thing is commitment to high quality, higher education across border. Does the institution adhere to specifically identified code of good practice? As all the agreements that I put, they are mentioning exactly what is the good practice in which the agreement was signed between University of Canada and other universities. Because University of Canada is advocating for higher education, and they are mentioning that in the website that we give the membership to the university based on these criteria. When there is integrity, when there is respect, when there is... I don't know if I can make some example. It's like when a person advertising, for example, it's just an example for a terrorist. Then I come to the person and as I say, look, this happened to me because I hear your advertise. And he kept saying, no. Did I conduct the terrorist? No, I just advertised and will continue to advertise. I suffered from this. It is a university that has a membership in University of Canada. Even if not if other universities does not have membership, but it got the membership through certain criteria. So they can interfere within the ground that they put in the website. There is also the quality assurance at the Canadian University. All of these are agreements.
If I look at the document that you're referring to under ground 2, it says under this authority, each Canadian university is autonomous in academic matters and determines its own quality assurance standards and procedures. Would that not suggest that it's not Universities Canada that's responsible for the day-to-day management of academic matters?
Yeah, this is the issue that I will talk about it on our lab. Of course, they have the immediate decision. It can be for the university, but now for the other grounds, it's mentioned that Universities Canada gave the university this membership based on this criteria, and if the university does not meet this criteria, the membership would be cut or broken, and maybe this section is maybe the university will be prevented from joining Universities Canada for 5 years. So they have, and it is mentioned that every institution or university, because it is not just take the membership and go. Every institution or university, they have to submit a report to Universities Canada. Did they meet these criteria every 5 years? So a report to satisfy the board. And if they did not, of course, they will submit the report, but what is the facts? So this is the criteria for Universities Canada. So there is some autonomy for the university, but there is also some criteria in which Universities Canada gave them the membership and to become a university, and it was mentioned based on this membership, the university is getting accreditation for giving degrees to the students. In the new website, they removed the word accreditation, or at least they are mentioning partial. Yes. So this is the also in the ground free honor in this letter, the mission and activities of AUCC. The mission of AUCC is to foster and to promote interest of higher education and university research. Main membership activities are to advocate higher education. It is the voice of Canada's universities. So they speak for the universities, and in the name of the universities, they are involved in many activities. And if I downloaded the videos in which the Honorable Paul Davidson is talking about education, because he is mentioning that these universities are following the good practice agreement in which, like Universities Canada, so they guarantee them, they advertise for it. And these are the voice of Canada's universities. For that I mentioned, like, they can't advertise for a university, then when there are so many cases, and that can be discovered easily from the proof, even they don't ask, and they say, we advertise for them and we will continue to advertise for them. What about the other grounds that are mentioned, that we can interfere if the report did not meet this? So they have a report every 5 years, every university. So it is not complete autonomy for the university. And this is mentioned in ground 4. The 5 commitments by AUCC, a strategic renewal of its activity that were stated in 2011. We commit to broadening the view of education. We are committed to innovation in learning. We affirm our commitment to excellence. We are committed to addressing the worst Sahar problem. This is another issue, and cultivating engagement. In ground 5 is the membership eligibility, and this is the most important, in which many words also has been changed. The membership of a Canadian university to this association and the accreditation of the university are based on meeting strict criteria, in which all of them are mentioned in the agreement. The criteria: there is integrity, there is safe environment for the students, there is everything. They can't say this in their ground, and then when all of that does not meet, they say to the students, Sahar, and that's it. It's not just a problem that happened, then I jump to them. I have documents and voice recordings for all the 4.5 years. And they know that if they did a statistic, what will appear there. So, and the accreditation of the university are based on meeting strict criteria, adherence to principle of institutional quality assurance, which are all mentioned in the agreement, and commitment to Canadian degree qualification framework. All of these are separate agreements in which mention in detail what the university should provide for the students, and in which I mentioned some of the points like fairness, and that they give equality to the students, and I have all proofs. It is not just saying. That are the framework and all everything that are reaffirmed every 5 years. by the report that they are submitting to ensure that a Canadian university degree is locally and globally recognized for its quality to guarantee the integrity of their academic programs and based on the mission of EUCC in advocating higher education. So every 5 years, the universities have to submit a report to show that all of these criteria, because AUCC is make commitment for these universities that have membership in Universities Canada, that they have equality and they recognize education globally and locally.
How is this all related to your case? I understand the points that you're going through. You're trying to show that the UC had on its website certain criteria for its mandate and how people became members. But how is this related to what your specific interest is in this file?
It's related on the other points that were mentioned in the website, that usually when there is an institution that will need to have membership at the beginning at Universities Canada, or later, like for example when they discover that it does not meet the criteria, it is mentioned that there is visiting committee. So how can, for example, a person in judge know that I have a point in what I'm saying or no? There are students that are recruited to work for the purpose of getting results, then they cancel their international student visa, and this is the procedure to fill the pocket of other students with results or no. How can they know? It is by the visiting committee, and it is mentioned in their website. I was exception in many cases, like if I go through Exhibit B, in which they wanted to cancel my visa in August. I was international student when I joined McGill in 2010. They wanted to cancel my visa in August because unfortunately the renewal of the international student visa is in their hand, and in July I became a permanent resident from application that I submitted long time ago before I come to Canada. And they tried many times to refer the result to other person, and I am not exception. How can they know that if they did not send a visiting committee? We know as a students in every lab who is the student who produced these results and who is the student who published these results. These are the lazy students. There is always a threatening in the lab for a student who is hard worker, and I can prove everything. I came till now, I will not go, of course, through the issues of McGill because this is not the main, but till now, the results that I submitted in Kuwait University are giving me publication till now. I have discovered it and I proved it. I synthesized cakes and I did everything. They just want to take the ideas and then cancel the student. I got award at the level of Canada between 33 students. And what they did, they kept just putting obstacles. And it was not, it was like every supervisor, okay, I will withdraw you, I will withdraw you. They don't want a student to have more results or graduate with GPA higher than their students. It was always the situation, and I have also the proof. So how can they know? By visiting committee. Because in all cases, it will not be hidden. I referred in one of the exhibits to a student, his name El Orabi, who went through the whole situation, but he decided immediately to leave from the first year, and he sent the threatening voice recording to the media. So he was able to reach the media. A lot of students, they were not. So it is the visiting committee, because once it will appear.
But the issues that you're raising, are they not related to McGill itself? Not with Universities Canada?
It's related to the ground of Universities Canada. We all know in our country about we hear and we, like when I looked at the website about education in Canada, if they want to make special rules and special behavior treatment that does not meet the criteria, at least cut the membership for them. Don't advertise for them.
So you're arguing then that the University of Canada should be withdrawing McGill's membership. Is that what you're arguing?
Yeah, since visiting committee take my right and they refuse, of course, and if it is the situation of a lot of students and they don't want to change it under the control of Universities Canada, they should. They mention it. I did not come to tell them what they want to do. They wrote it. So I was surprised from the way of it is easy like that to establish an association by an act of parliament. Then when anybody sends a request within the ground, nothing happened and everything hiding in all the association. When I sent email, like in CIMIC, even like other members, they send reply. They avoid always to have like the responsible person to decide, to say the first thing that the decision was not taken by the president. So it's just roaming for collecting reasons. Once they say the decision was not taken by the president, okay, let's make a cross-examination and see who is responsible. I have the emails and the name of the ladies. Maybe there is corruption, a breach of trust. So the issue started after that, just collecting excuses for striking the application. And in Article 8 from the membership eligibility, its approach to the protection of academic freedom respect the spirit of AUCC statement on academic freedom, which was approved by the membership on October 2011. As maybe
if I may just ask it, could you just let us know what page you're reviewing? And I apologize.
Exhibit AG.
Exhibit AG. Is there an actual page reference in the document, or we just will go to?
If you look
I
at
have
the
720
exhibit,
here.
No, not if you will look at the exhibit alone, it is page 8. Because like some of the pages here, like I printed 2 pages together, so the number it can be different from the record, just the numbers.
That's fine. Thank you. We'll try to catch up.
Yeah. And there is a statement of academic freedom, and also there is mentioning that there is visiting committee for any institution wants or university want to join Universities Canada. So after that, in after the letter, the email in 31st of March, in which I sent to many members, because I knew that before I sent the first email, I called and I requested the email of the president, and they give me certain email. So I knew when there is no response that they are trying not to respond. So this is in 31st. And after that, the letter that I wrote to the receiver of this mail, do you see it? Yeah. This is in which like the video here show everything I put, and I have the name of the person. I don't recognize, I don't memorize or recall who is the name, but also she is other lady different than the other members who sent the email. So, dear receiver of this mail, the signature at Canada Post shows who received the mail. Please give the envelope to the Honorable Paul Davidson without opening it unless authorized by the Honorable Paul Davidson, because I wanted to show who is responsible. And then the first email from Helen Murphy, after I went to Universities Canada, the receptionist did not allow me to enter. She told me you should call, and I called, and a member told we cannot do anything. So this is the reply from Helen. Good morning. We have received your recent communication regarding your situation at McGill. Please note that we have no involvement with the academic decisions or internal operations of our member institutions. For follow-up on your concern, please contact the Dean of Students. So this is the decision.
This is the decision that you're seeking judicial review from?
Yes, so there was a decision. They are trying first to hide and roam around not to give a decision, but when the demand letter was submitted to them, they gave a decision. And the decision also from Helen also in the second email, when I told her that the letter that I sent is a demand letter to the Honorable Paul Davidson with the grounds clearly and legally stated and clearly indicate the rules of membership of a Canadian university to AUCC. Could you please indicate if the letter and the documents reach the Honorable Paul Davidson or not? The decision should be informed by a letter officially signed from him, and he will be the first one invited in the court and responsible for the decision. Because I have roamed all the associations, even like in Quebec, and I can say the letter and all the documents that I submitted to the human rights like were suspended from January till now, just because it has a proof. And I wrote the letter is among the exhibits. Every letter was scanned. The sentence that does not have discrimination was taken. The sentence that has discrimination was deleted. Same situation as the grievance at McGill. And Helen replied, as stated, Universities Canada is not involved in this area in any way. So this is also a confirmation that there was a decision and that can be reviewable. Please note that Universities Canada is not an accreditation body. If you wish to pursue your concern, this must be through the Dean of Students at McGill. And I can say that since I started, I was always going to all the deans, Dean of Faculty of Medicine, for example, Dean of Students, and I mentioned for them that I exhausted all the possibilities at McGill, and they are telling that the decision will be for the chair of the department. And the chair of the department is the one who performed with McGill principal like giving her only like more position. She performed all the discrimination. She told the supervisor cut the money for her. She told in her letter, I will not give you like financial assistance. She told me I will withdraw you after I got also a decision from the dean. She played with my transcript. I can show everything is in accuracy that will need even these days. So there is always a role. Since I am from the beginning in this situation with a chair, and I showed him the proof who is telling I will withdraw you, and I finished with a GPA 3.72. There is always rule in every association. Many of the failure of this association is that because when a situation that does not work, they keep the decision in the hand of the same person, just like it. So this is like a rule for the association. They spend like millions of money, but they keep the same situation and nobody cares. So it's not that I refused, for example, to go to the Dean of Students. I mentioned for them, I exhausted everything. I supported for them the document, and from the beginning I mentioned this is confidential email and letter to the Honorable Paul Davidson. So all of that behavior does not show like also a behavior for organization established by an act of parliament. But there is a decision. Since there is a decision, it is confirmed and it can be reviewable.
So just to make sure that I understand, you got a May 6th email that's sent to you from Helen Murphy, in which she refers you to the Dean of Students. That's the subject of the judicial review. That's the issue that's going to be judicially reviewed.
The two emails.
The two emails.
Because
we have one, and the other one is at what page?
I can refer in Exhibit AG alone.
What's the page number?
In Exhibit AG, like page 15 and page 16.
Okay, maybe I can do this another way. You you're referring to two emails by Helen Murphy,
Yes.
and I have
The first email, both of them show 6 May. The first one starts with "Good morning. We have received."
Yes.
Yeah.
I have that one.
And the second one is in the second page when I wrote, "Dear Helen, the letter that her answer is below my email." This statement.
As stated, University of
Yeah.
Canada. That's the second email.
Yeah. But
Okay.
also my letter was not sent to them. But this is what I got over the phone from one lady and by telephone. In the first email, she CC Josie Gengras and Nadine Robitelli. I don't know if I pronounced them correctly. And these are also whom they put their email in the website. And this, in the second email, she just CC Josie Gengras.
And on what basis are you founding yourself that these emails did not find themselves, or that they were not communicated to Mr. Davidson?
You mean how I translate them?
No, how do you know for sure? You indicated that you've sent two emails to Mr. Davidson directly.
Yeah.
You've sent a letter, and then you have correspondence with Helen Murphy. Now, how do you know for sure that this wasn't communicated to him?
Yeah, when I mentioned this in my record, because the lawyers, they mentioned that my affidavit and everything I'm claiming is based on assumption or speculation. So it's yeah, I can. I just wanted yeah. It is in page 25 of the record. As I stated in my letter to the Honorable Federal Court, the lack of response from the President of Universities Canada does not necessarily mean that he was not aware of the situation. Same action happened from many employees. This is what I mentioned. Despite the fact that there is possibility that the Honorable Paul Davidson was aware of my email's letter request, I did not make assumptions and speculations that he knew about them. I expect that he knew, but he was, because this is what I expect, but I wanted to show that who is responsible also for the decision, and they are refusing, because if it is mentioned that he took the decision, it means he is responsible. If it is mentioned, this is what I expect, through, if it appears through the cross-examination, that he was not aware, it will show that there is a breach of trust and other things from behavior of the employee. So I did not make assumption and speculation that he knew about them, despite the possibility that he made. No assumptions or speculations were made in my application, as the respondent's claim in point 3 of the respondent notice of motion and point 5, page 6 of the motion report. I wrote what happened, what is obvious from the action of the employees of Universities Canada, and requested a cross-examination or examination of the honorable and all responsible employee in front of the judge to know what happened and who is responsible for the decision. Therefore, I included Universities Canada also as responsible. And here, when I wrote also that in fact they wasted time, and this is considered infringing of the right of communication, because they wasted my time and they are not losing any time or anything while they are sitting in their office while I am using in my time. And the communication, the right of communication, according to references that I wrote in the response, it is the right to inform and to be informed. So from the beginning they ignored, and also I want, if he was not aware, I wanted to inform him. Give him, like when I sent a letter, give to the person let him think about it, give a clear decision with signature. That will show really if the association is confident that they are following their grounds or not. So this is also in response to the point that the lawyers mentioned, that there was no exchange of emails, there was no decision, and there was no cause of action. There is exchange of emails, and there is decision would need to be reviewable, and because also it does not follow the grounds, and because of the whole situation that appears like that.
Okay. So that's your argument on the decision?
Yeah. Or
the argument in response to counsel's argument that there's no decision.
Yeah, at this point.
Okay.
Yeah, to this point.
Now, with respect to his other argument that the Universities Canada is not a federal board, because that's also a requirement under the Act, it has to be a federal board. What do you have to say in response to that?
Yeah, this is what I mentioned on our like at the beginning, that the exhibit that I put when Universities Canada defining themselves as we are non-governmental established by an act of parliament. This is the first. And the second thing, by Rule 58, Section 2, a motion under subsection 1 shall be brought as soon as practicable after the moving party obtain knowledge of the irregularity. So when they send their response in 10 of June, if this is included, immediately they should have, for example, if successfully strike the motion. And not mention we will respond, I will submit affidavit and exhibit, then they will say that it is vexatious as everything without referring to any exhibit. Because all of them, they have the proof that it is not, as they mentioned, in Role AC. And after that, they started just to collect the excuses, to put cases from previous judges. I know that the judge can refer by analogy to other cases, but every case is unique. So this is like what all their motion record is concentrating, filling the record with the previous cases. Every case is unique. Maybe the other cases they brought it immediately for the irregularity. So Rule 58, Section 2, maybe it does not apply for them. So every case is unique. Like you, in order to make analogy, for a person to make analogy, like he needs to take the whole situation. Also whether there are infringing of a human right or nothing, maybe there are not other breaking of acts or rules like that. So every case is different. So they did not refer to any of the exhibits, they just referred that I mentioned about the good practice. The good practice is a word in one of the agreements. And there are proofs and exchange of emails.
Do you have anything more to say? I understand that with respect to the argument as to whether or not Universities Canada is a board under Section 2 of the Federal Court Act, your argument is that because it's an act, it's been created by an act of Parliament, that in itself is sufficient for this court to have jurisdiction.
Yes, and what the grounds that are mentioned in their website, it means that they have the authority to interfere in a situation of any university, not necessarily McGill, to see if they follow all what is written, not just only to advertise for them and don't care. And I will just before the phone. Yes, just only another one point regarding the whether the institution. I read like some of the cases or like in which there was referral if the institution is public body or not. But there is debate about like the definition of public body, because like my situation, if the visiting committee investigated the situation, they can show, for example, that it is public. There are a lot of students that are in the same situation. It affects the reputation of education in Canada, so it is public. So there are many different definitions, so we cannot take it clear cut that it is not a public body, because there is no like a specific rule stating if it is a public body or not. So this also like something debatable and cannot be taken as a ground for the motion to strike. So I think like the application that I submitted for judicial review, it has a decision from members of Universities Canada. It has also insistence on refusal to follow the grounds, because from the reaction now after like the submission of the judicial review, it is insistence and meaning that the chair now he knew about the situation. Before that he did not know. So there is insistence, and also there is I don't know if I can say, for example, or I can say inappropriate way in handling the situation, and just wasting my time and infringing of my human rights without for them taking action. And especially, for example, I can refer, this is just an example, on their letter in 10 of June. If they want to strike based on irregularity, they could have sent the motion to strike immediately. But since they sent it later, they even did not refer to my exhibit because they have a proof, meaning that the grounds that they are based to strike the motion are not applicable in my situation. They told that they will respond, meaning after they examine the affidavit and exhibit. If they examine them and there is no proof, let them refer to the exhibits and give response to my points. So they are responsible for the wasting of time. So there is decision which can be reviewable. It is also included in the authority of the federal court. If they are saying it is not established by an act of parliament, I don't know how can I refer the issue to the parliament, because everybody is closing the door to see why they established it. When we get the answer, we can know. But for any organization, when it is established, it is for the reason that they wrote in their website, for the grounds that they wrote. So the Honorable Federal Court has jurisdiction also to interfere in this situation, and they can, I mean, it is not applicable or clear cut about the definition of public body, because that there are many definitions that are debated.
Your defendant or respondent makes a distinction because there's a lot of discussion about public body. There's also a discussion about public and private nature of what the act or thing that's been done. Do you have any comments on that?
Actually, I have no idea about this, but I think even if they have a point in this debate about the public body and other things other than Rule 221, they are like they can be they cannot be taken if the Rule 58 Section 2 was considered.
Okay, but that Rule 58 has to do with the timeliness of their bringing their motion. One of the arguments made by the opposing party is that when we're looking at Universities Canada, we have to look at the characterize the action that you're complaining about. Was it public in nature or was it private in nature? And he referred the court to case law that provided examples of what could be considered public action versus a
Yes.
private action. Do you
Yes.
have a position on that?
Yeah, but if we look honor at the definition at section 2 of the Federal Court
Court
Act, it does not state if it is by, for example, a public act of the Parliament, by an act of Parliament, which means applicable in universities Canada. And I do believe that the issue for every case is it's like a balance. It's taking all the issues and factors into consideration, like the issue of the public, whether it is included in federal, the time also for wasting time. It means that it is not a sort of irregularity. If it is irregularity, they could have brought the motion in 10 of June mentioning you can't because Universities Canada is not a federal board and not under this act. So since and the rule is mentioning shall. So every case, I did not have an idea to understand law in all of it, but every case it is a collection of all factors. So it's not just only reading certain paragraphs, yes, but there are also for every case other rules and other situations.
Do you have more
Yes.
submissions?
No, the submissions are in the exhibits because if I will go through that there is cause of action for what I sent for them and the agreement, the good practice, that will need the time. But I know that it is not the rule for them.
And it's all in the documents that you
Or
Okay.
only honor the video. That it just only show what I put and the letter, dear receiver of this mail, and the CD that I put. I just was taking video for my hand, so it's not for other people.
I don't have a position necessarily on the question of the video. If it's just to demonstrate the documents that you show,
Yeah.
I don't think that's an issue.
The video in that circumstance. I don't think there's a debate about the fact that the genuineness of the and authenticity of the emails that Mr. Jaffal submitted.
Okay.
And the voice recording, it's just show when I go to the receptionist and she told me you have to call, and when I called and they told me we will not take action, so we cannot do anything. Then I told her I should take response, so that can be.
Okay. I don't have.
I think we have the audio tape. I thought that they had been delivered to us, but I don't think that they were. But I don't think there's any issue as to the chain of events, the circumstances that Mr. Jaffal has described in any event. I think that whether they're entirely precisely accurate, generally speaking, we're content that that chain of events did take place.
Okay. Well, then I don't think that it's necessary for this court to have that. As counsel on the other side has indicated, there's no issue with respect to whether or not it happened, and I think what this court is going to be looking at is the emails that you have provided to the court as constituting the decision. This is a judicial review.
Yeah.
Now, what I would like to hear from you, if you have any comments, is with respect to the remedy that you were seeking from this court. In your application, you outline a series of relief that you're seeking, and I'd like you to explain to the court under what authority this court could grant the relief that you're seeking.
Yes. So for me, the most important honor, when the lawyer mentioned that I requested that the decision to be under the custody of the Honorable Federal Court, because after the situation that happened from March till now, and in many associations in Quebec, for me, I can expect that they can say, okay, we will make a visiting committee, then they can submit, we will take a decision or make a visiting committee. Then the situation, it will be in the hand of the same employee who are trying just to hide facts. So for me, I want my rights. I have all the proofs. and what I face at McGill since 4.5 years, and I have all the proofs that I produced results there, and I got awards inside McGill and outside, and what they did to cut the award of me when I was competitive to their students. I have all the exams. I have the last contract that was saying finish this course and submit the thesis, and I finished, for example, the course with A grade and with GPA 3.72. So I have everything, but I cannot trust to keep the evaluation of the visiting committee just like that. We made a visiting committee and we found that McGill followed the good practice. So it should be submitted to somebody who can make fair judicial review.
Okay, but what I'm asking you to do is to respond to the argument that was made by counsel with respect to the ability of this court to do what you're asking it to do. It's one thing to look at the decision. It's one thing to look at whether or not we're dealing with a federal board. But the other thing that one has to consider is whether or not is the relief that you're seeking in the judicial review application is something that this court has jurisdiction to do. Now, your counsel made an argument that these were things that this court could not order Universities Canada to do. Do you have a position on that?
The issue is that what I mentioned, that it is involved according to Section 2 of the Federal Court Act. So if the decision was reviewed, it will be reviewed that they will take action, and what action. So this is from my understanding in terms of the jurisdiction. So if the decision was reviewed, it can be for both. That they take the action, and what is the action to prove that it was taking the action. It's same when the judge give a decision for any single person, for example, to do community service or something. So the judge gives the decision, do this, but the file will not close and the person will go. Proof that you did it, at least. Who went? For example, if the judge is satisfied that a visiting committee or they should follow the ground, okay, visiting committee was established, who went, whom they met, what are their names, like that. And at that time I will know, because I have all the exhibits, if they were really at least good written representation from the responsible people, even not visiting committee. It's not necessarily to go every time to Quebec and investigation. No, they have authority. Give us written representation for this fact according to this email and the questions that she is asking. So this is what I have. If the federal court have jurisdiction for reviewing the decision, also for taking a proof that the action has been, especially after seeing all this going around and wasting of time and trying to collecting excuses for just a motion to strike.
Just want to make sure that you understand my question. In your application at page 13, you request that a visiting committee be appointed by the Board of Universities Canada. You're also requesting that you be allowed to meet the visiting committee. You're requesting that it interfere in the evaluation of your PhD. Is it your argument or position that the federal court could order on the merits, not on this application, but if we decide not to strike the application for judicial review and it goes to another judge who hears the whole matter, that at the end, when all is done, that the judge will be able to order the things that you've requested in your application?
No, it's not a direct order. These are the issues like the evaluation of the PhD and the preventive of the university for me, for example, to get external member from outside Montreal. Although I got original, from them. So this is among what I requested from AUCC, because if they make a visiting committee, this is included in integrity, good practice. So it is not necessarily from the federal court, although I read a rule that in a matter, if it is necessary, the judge can invite an expert or examiner, but I forgot which rule and in which case, to see, for example, the situation. But I don't think that, I did not mean that it is directly from the court. But this is among the action that will be proven by Universities Canada, because I have the proof of what happened and everything, and the changing of the time of the exam so that nobody, the way that McGill changed the time for the exam, they sent email to all people with wrong time so that nobody attend, and their behavior, I have a proof for it, but it is under the action of Universities Canada. But
when this court has to make a judgment and make a decision, it's going to have to decide something. It either can set aside a decision or it can order something. And what is it exactly that you're seeking from this court? If the court finds that you're right in your submissions, what would you be seeking from the court?
Yes, this is what I'm seeking is a decision that, for example, Universities Canada made a wrong terrorist decision and reviewable, and the court is reviewing this decision that they have to interfere according to the ground. So this is one, and to prove with the action. The action is for the points that I mentioned, and for the visiting committee. So this is the action to be submitted, like I mentioned, Honor, when a judge gives a person any decision, the file is not closed unless it is proven that the person served, for example, a statement or made a community service or something. And for all the time that has been wasted for this issue, I ask that the respondents, they are responsible for the damage. I'm not sure about if the court is giving damages or the federal court. I know about the superior court, and they are responsible for the cost.
There are two things. There's costs and there's damages.
Yes, exactly.
The court can award costs if you're successful. If you are successful, it's my understanding that you'll be seeking costs.
Yes.
Do you have anything else that you want to add?
At this point, no. I wrote a lot of points, but I don't think that I have something.
Those are your submissions?
Yes.
Thank you very much.
Thank you.
Reply?
Just 2 moments. I just want to make sure that our position is clear that the Universities of Canada is not an accrediting body, and hopefully I guess the only evidence in front of you, such as it is the emails from Ms. Murphy explaining that to Ms. Jaffal. I think the only other point, I don't know that it's necessary, but Rule 58 I don't think with respect doesn't apply to these circumstances. It speaks to irregularities in the pleadings and in the process. Obviously, where the Rule 221 actually, in its language, contemplates bringing the motion at any time during the proceedings. And we would submit that the timing in which we brought the application was entirely consistent with the intention of Rule 221. The only other thing I want to say was just to finish. This morning you asked me about costs, and I do have instructions. And our client is prepared to waive a request for costs with respect to this motion, and but reserve its rights for the purposes in the event that the court were to decide that the application should go forward. Then we
just so that I understand correctly, if you're successful today, you're waiving costs.
Yes.
If you're not successful, then the costs would be, no, I guess it's not an issue of cost.
No, it's really, we're just for the...
You're not waiving costs on
the
whole
application at
division.
large,
Okay.
yes. And so that may be some assistance to you today.
Okay.
But otherwise, unless you have another question, I think that for the most part, our arguments have already been made, and there's nothing that's new. Thank you so much.
So I take it under advisement. Thank you very much. Thank you.
Order.